constitutionality and voting. My Vote Counts has taken its fight to the Western Cape High Court and wants all political parties to fully declare donations received. Now, currently, the Act does not require parties to disclose donations under 100,000 Rand and allows excessive individual donations of up to 15 million Rand per year. But My Vote Counts legal representative, Vlad Movshovich, I think is how it's pronounced, described the disclosure threshold implemented as irrational.
All exercises of public power to be rational and lawful. That's a fundamental requirement, and that cuts across all legislation. So irrespective of whether specific constitutional rights are implicated. At a second level, if specific rights are adversely implicated and we can establish a breach of those rights, then the onus shifts and the state has to justify it on the basis of Section 36, that limitation. And we say that on both those grounds, the disclosure threshold fails. First of all, it fails. The disclosure threshold fails to be justified at all as a disclosure threshold. There shouldn't be a threshold. But to the extent that Parliament saw it fit to have any threshold, the threshold that they've chosen is not supported by any evidence that was before them or that they considered. And secondly, it's fundamentally irrational.
All right, around My Vote Counts, we're joined by independent elections analyst Michael Atkins. It's always a pleasure talking to you. Thanks very much for joining us, Michael. Is it naive to think that we all want more transparency insofar as political party funding and donations is concerned?
Good afternoon. Yes, it probably is a little bit naive, but then my response would be that our Constitution sets very high standards for the exercise of democracy, and it is not an unreasonable pursuit to seek the best possible transparency around this, albeit that it's understandable that there will be resistance to this in various quarters.
Action SA is one of the parties opposing this application by My Vote Counts, but to be clear, it says in its statement that it's not opposed as a party to transparency, but this application is short-sighted. It's intended to throttle party campaigns, and questions need to be asked about the intentions of this organisation. That's quite a cynical way of looking at this application by My Vote Counts, is it, Michael?
Look, the comments about My Vote Counts by Action SA, in a sense, we can ignore the subjective comments. You know, when you decide what's right or isn't right, playing the man rather than the ball sort of doesn't really advance us. Action SA does raise important questions, and it is reasonable to disagree with the very particular proposals for relief sought by My Vote Counts. Mm-hmm. And the great thing about our democracy and our legal system is the courts will get to hear both sides of this argument, and a reasoned, well thought out judgment will result at the end of it. So this is a great discussion to be having, whether there should be a threshold or whether all should be disclosed. That's a good debate to unfold in the next few days.
Yeah. So what the lawyer for My Vote Counts has argued in court today is, particularly as it relates to that 100,000 Rand threshold for donation, for disclosure of a donation, and a 15 million Rand annual limit. What the lawyer for My Vote Counts says is that, you know, I could very well set up a whole range of companies and make several donations just under the threshold and stay under the radar. I mean, that's a fair argument.
Look, it's clear that the enforcement of this legislation has a lot of questions around it. Firstly, the capacity of the IEC to carry out any kind of investigation. We can look at the natural ways that might arise to sort of bypass the provisions. And it is perfectly reasonable over time that we look at tightening up the rules to avoid any exploitation of those rules. But of course, it's important to realize that the My Vote Count application goes further than merely doing away with the threshold. For example, the argument that the changes brought about a year ago, giving the president full discretion over the donation limit and the threshold. To my mind, that is a strong and urgent concern, that the original intention of the Act and the original constitutional requirement is not being met if the president can summarily change the limits without any restraint. Now, those arguments will be very interesting to watch in the court.
Yeah, and Action SA's arguments around, this potentially threatening even election campaigns in the future, putting such a drastic limit on what donations parties can receive. But what My Vote Counts is countering with, its counter argument is that it's not just about the funding issue, it's a voting issue. Because me, as a voting member of the public, you and I, we deserve to know whether the party we are voting for is being funded by principally the kinds of organizations we would ascribe to.
Look, you're correct. The 2018 Constitutional Court judgment, the My Vote Count judgment, that action led to the Political Funding Act, essentially. That makes it very clear that Section 32 of the Constitution, the right to information about private funding of political parties, is clearly tied to the right to vote. So in some senses, I see Action SA and My Vote Counts as having fundamentally the same aims, but having a difference of opinion partly around practical considerations or perhaps unintended consequences of the particular principles. So in a sense, I don't see it's a problem whether there is a moderate threshold or there isn't, so long as there is reasonable access to information for voters, as you rightly highlight.
So Michael, in your experience as someone who is an expert in election matters, how much should we know about the funding of the parties that we support? How much transparency should there be? And not even in an ideal world, but just generally speaking.
Look, it's very important. As I said, that 2018 judgment makes it very clear that the right to information, alongside our, we will know higher, but the Political Funding Act was essentially required because that needs to be extended to the political realm. So whatever reasonable access to information means, and this court will reach a determination about the meaning of that. It is essential that we do have reasonable access, and that those limits cannot just be arbitrarily doubled or tripled whenever the president or parliament decides to make a change ahead of an election.
Yeah.
So there needs to be very strong constraints. Whatever the limit is, if there is one, it mustn't be possible to just change it arbitrarily because that's convenient ahead of the next election.
And that's the thing about the Constitutional Court ruling, isn't it? That it contains those two words, reasonable access, and they carry quite a bit of weight. What qualifies as reasonable access?
Well, again, it is the beauty of our democratic order and our legal system that this question can be brought and that it will be hammered out. And if the High Court says or does anything wrong, sure, it will go to the Supreme Court of Appeal. We have a tremendous privilege that these questions can be aired and hammered out. For me, democracy is a winner, regardless of the precise outcome of this particular case.
Yeah, you're absolutely right, Michael. We can be asking these important questions and asking them pretty loudly. Michael Atkins is an independent elections analyst. Thanks very much indeed, Michael, for joining us this afternoon.